Procedural. Well, sorry, we'll take up the division bench matter at 2 o'clock. Yes.
I can go
Hmm.
after
Huh? After?
2 weeks. Your Lordship.
On the prayer of Mr. S.K. Devi, learned counsel for the petitioner. List this matter after 2 weeks. Huh?
Right. Yes, sir. I beg to mention item number 25.
25.
With concern of other side, I am praying for the listing of matter after 2 weeks.
Hearing matter.
Hearing matter.
What is there?
Another is pertaining my Lord, eviction matter. Eviction matter.
That's what I'm saying. What's there? Nothing.
2 weeks matter.
You don't want to deduct before this court?
No matter, not.
Are you apprehensive?
No matter. Not like.
Okay. On the prayer of Mr. Elper Melan, consider this matter after 4 weeks. 4 weeks.
Better, otherwise, we write for it. If it can be listed next week.
Lucky. Dolang lucky.
Yes, next week for admission. Or
Next
after,
week.
yes, or after a week. It's your lordship.
On the prayer of MS Endangin learned counsel for the petitioner, means this matter after a week, so as to enable her to file.
Lordship, it may, no. I'm filing it today itself. It may be listed for admission or next.
MS Endangin learned counsel for the petitioner submits that she would be filing the affidavit reply. Affidavit reply during the course of the day.
Yes.
And therefore, phrase for distinct matter after praise the Lord.
For admission, lordship.
For admission.
Okay.
Should I take mention one item? It's not listed today. It's been instructed to do it. Well,
Tomorrow.
Lordship, I would like to mention one unlisted matter.
What is the urgency tomorrow?
It's a tender matter. Lordship.
Tomorrow.
My Lordship, with the consent from other side, I beg to mention item number 11, Lordship. This matter may be fixed on the 18th, Lordship.
18? Why 18? Why?
Lordship, I have been instructed to mention for 18, Lordship. 11.
On the prayer of Mr. So-and-so, and counsel to the police. You are the
Respondent number 7, Lordship.
respondent.
Or we have Mr. Kititara. No, you're mentioning.
Prayer not being objected to by learned additional general for the state and the petitioner. List this matter after a week.
18th, Lordship, I have been instructed.
After a week.
And Lordship, item number 26, I am for the petitioner, Lordship. I take consent from the respondent, Lordship.
Why? Item 26.
Lordship.
What's wrong with Mr. Tara?
I'm sorry, Lordship. He just instruct me to mentioning this matter for 18, Lordship.
Not 18. After a week.
Obliged.
Good.
Obliged.
My belief, Lordship. Lordship, I beg to mention item 1 3.
Item 2.
3, Lordship.
3, yes.
Here, conducting counsel, Mr. R. Mr. is not appeared today. due to personal difficulties. Lordship.
Who?
R. Mishra, Ravi Shankar Mishra.
Item 3.
Yes, Lordship.
After 3 weeks.
Lordship,
After 3 weeks.
no, Lordship fixed that may be given 29, Lordship.
Yes. Yes.
Deeply obliged.
29. Make it 20.
I am absolutely sorry, my lord. In item number 21, my lord, yes, interim order, my lord. Let me be kindly continue.
21.
25 minutes.
Well, better it. What's there? Okay. Tribunal.
May I please, madam?
Yes.
Malad, I like to mention item number 14, 15, and 16, analogous method.
Hmm.
On behalf of K lawyer, madam.
Hmm.
Malad, as per instruction, malad, this method may be listed in any other appropriate bench other than you.
Why?
Malad,
Okay. 14, 15, 16.
14, 15,
List these matters before any other appropriate bench would have been.
deeply obliged.
May I, Your Honor? Your Honor, I beg to mention item number 8.
Hey,
Yes, sir.
yes.
For the petitioner, and matter may be listed after 2 weeks.
2 weeks.
Highly obliged.
Item number 1.
Wait, please, Your Lordship. My lord, in the year 2024,
Hmm.
there was a competitive examination.
Hmm.
And during one of the paper, mobile phone was found from me.
Hmm.
And accordingly, I was debarred from further participation from that examination. My lord, then there was another advertisement in the year 2025, in the month of May, for another service. My lord, there I have also applied. My lord, my application was also assigned the application number, but my acceptance or rejection was kept withheld. My lord, may I come to your lordship said page 48 onwards, annexure 7. This is the advertisement. Then, my lord, annexure,
Engineering service sector.
yes, my lord.
Yeah.
Then, my lord, at annexure 8, page 55. This is a notification. At page 56, my candidature has been kept withheld.
Yes.
Then, my lord, at page 57, I have submitted one representation to know the reasons why my candidature has been withheld. Then, my lord, at page 58, my lord, excerpt 10, my lord, the so-called notice was issued. My lord, may I read, my lord? Because
Yes.
this is the basis is the same.
Yes.
Whereas, as per the report of the Center Superintendent, KB number 1, Naharlagan, during the compensatory time allowed to PW candidates, you were caught red-handed with a mobile handle while coming back from washroom on 15/12/2024. And whereas later on, the mobile handset was seized by the police and kept an exhibit for future evidence in the court of law. Whereas carrying or use of any unauthorized electronic or mechanical instrument or gadget inside the examination is a gross violation of the APPSC Manual for Conduct of Examination 2024 and other instructions of directives enforced, which also amounts to commission of an offense of unfair means made punishable under such and such. Now, therefore, you are hereby so caused as to why you should not be debarred from taking any public examination in future. Your written explanation should reach the APPSC on or before 24 July 2025. This is the same incident which occurred in the previous examination, which was held in the month of December 2024. That is for the Arunachal Pradesh Civil Service Preliminary Examination.
Yes.
Now, Malad, at page 59 onwards, Malad, I have submitted my reply to the so-called notice. I have given the detailed reasons. Malad, I have assigned various reasons also.
You have admitted.
Yes, Malad.
Admitted.
Malad,
It was
Ma-
found.
Yes, that's why,
What
Malad.
was found?
That is it for the previous examination, Malad. And I have resigned myself, and I did not object to that punishment. Now, Malad,
Yes.
at page 61 in Excerpt 12, this is the debarment order, Malad. May I read, Malad?
Yes.
Whereas during the Arunachal Pradesh Public Service Combined Competitive Preliminary Examinations 2024, held on 24 December 2024, as per the report of the Center Superintendent KB number 1, you were caught red-handed with a mobile handset while coming back from the washroom during the compulsory time allowed to PW candidates. Later on, the mobile handset was seized by the police and kept for future evidence. Whereas the carrying or use of any unauthorized electronic or mechanical instrument or gadget inside the examination is a gross violation of a PPC manual for conduct of examination, and this information has been clearly communicated to all the candidates by way of advertisement and penalty therein dated 5 August 2024. This amount to commission of an offense under 3F of unfair means made punishable under Arunachal Pradesh such and such, my lord, and the PPSC rules 2019. Subsequently, a committee was constituted by the commission by order number such and such, dated such and such, to examine this case of unfair means where a mobile phone was recovered from the physical position of one PW candidate. Further, a so-called notice was issued to you by letter number such and such dated 18 July 2025 to submit a written explanation within the stipulated date on 24 July 2024. And you gave the written reply on dated 21 July 2025, and the reply statement was examined by the commission and report was submitted. Whereas on careful consideration of the statements of the Center Superintendent,
You've been debarred for 1 year.
yes, debarred for 1 year. Malad, at page 62, Malad. Malad, here, third paragraph, Malad. Further, on the basis of the report submitted by the this is the enabling provisions. Malad, last paragraph. Whereas after the careful consideration, the commission by invoking rule 11K sub-rule B1 of the Arunachal Pradesh Public Service Combined Competitive Examination rules hereby debar you for a period of 1 year from the date of issue of this order for all examinations conducted by the FPSC with a strict warning that any repeat of offense will lead to permanent debarment by the commission. Now, Malad, let us come to these rules 2019. What is this rule says? Malad, may I just take your lordship to page
Issue notice.
64? No, Malad, Malad,
Issue notice.
Malad, only one rare, Malad. Since preliminary examination has already been held on 21, and Malad, preliminary examination is only for, this is a screening test only. Malad, here I have annexed the provisions also at page 7115, Malad. Kindly
71.
71.
Yeah.
Malad, this is the schedule of section 1, plan of examination. This is part of the rules, Malad. Number 2, Malad. The preliminary examination will consist of 2 papers of objective type, multiple choice question, and carry maximum marks in the subject as set out in section 2, part A of this schedule. This examination is meant to serve as a screening test only. The marks obtained in the preliminary examination by the candidates who are declared qualified for admission to the main examination will not be counted for determining their final order of merit, Malad. Now, Malad, my respectful submission is, Malad. Malad, this is a once in a lifetime opportunity, almost like that, Malad, especially in the electrical wing. Now, my lord, I have completed my BTech, MTech also in electrical branch. Now, my lord, this examination is coming up after almost a decade for the recruitment to the A post. Now, my lord, my result submission is that
You have
they could not have.
you have earlier you have filed a written petition.
Yes, I have filed a writ petition, but
You withdrawn it.
because we have challenged that the so-called notice. But by that time, the
The preliminary exam is over after. Then we-
my result submission, supposing as on today, we find that this impugned department order is held to be not sustainable, my lord, then the consequences has to follow. Therefore, my lord,
Have you annexed that order, the withdrawal order?
yes, my lord. Because that was, my lord, that department order was issued on 24th. We filed the case on 24th, but department order was made available only on 25 when this honorable court was taking up the matter. Then therefore, my lord, no effective order could be passed. Therefore, we had to withdraw, and we have taken liberty to file. Then, my lord, we are approaching now. Now we are challenging the department order. Now, my lord, apparently this department order is not sustainable because I have been already punished under the provisions of rules. And the rule says, my lord, there is a word or.
Let us see the rules.
Yes, my lord. My lord, may I just come
which
straight
rule you are-
page 66, my lord.
Yes.
My lord, clause 11, my lord. A candidate who is or has been declared by the commission to be guilty of, my lord, then come down to G, using unfair means during the examination.
Yes.
Then, my lord, coming to K, my lord, may I read my entire K? Violating any of the instructions, I think it should be violating any of the instructions issued to the candidates along with their admission certificate of the call letter permitting them to take the examination or commission, or as the case may be attempting the commission of all or any of the acts specified in the foregoing clauses by a candidate may, in addition to rendering him liable to criminal prosecution, be liable A, to be disqualified by the commission from the examinations for which he or she is a candidate, comma, or the word or, to be debarred permanently for a specific period, my lord. Now, my lord, my respectful submission is these are two separate punishments, and this cannot be imposed cumulatively. It has to be independent. These two are two different sets of punishment, and this cannot be done cumulatively. In my case, my lord, in the year 2024, I have already been debarred under sub rule A. Now, my lord, they are again under sub rule B. They are again debarring me. Now, my lord, this is totally double jeopardy. So, my lord, therefore, with this background,
Article 22.
my lord, therefore, my lord, with this background, because
You want us to read, you want to read this provision, this auxiliary verb has to be read and
not
once
N,
it is
not
or-
N,
no, it is if it is or either of the two.
either of the two. That is my submissions, my lord. So they have imposed these two punishments. Now, my lord, I have in prima facie, I could show that this could not have been passed.
So today we cannot turn the clock back.
No, my lord, my resolution submission is
Exam is over.
no, my lord, my resolution submission is supposing since preliminary examination is only a screening test. Yes, I have, my lord.
So what do you want?
So, my lord, at least the main examination is coming up on 6th and 7th September.
will be very difficult, sir. There's a examination, there's a concept of examination. I mean, there, so many people might have been disqualified in the group case. Very difficult.
My lord, in our case, this is only single
You may
case.
have a,
Otherwise, my lord,
you may have a valid point, but it's been
otherwise, my lord, may I submit that since examination is coming up on 6th and 7th September, we have some time. So let us make an endeavor to issue notice for 7 days. Let us try to dispose of this writ petition itself.
very difficult. Today we cannot do it.
My lord, yes. I agree, my lord. If there is some, but then my response submission is, my lord, she cannot be made to suffer in this way, my lord. So, my lord, this court is a epitome of justice and equity, my lord. So, if no interim order can be passed today,
It's not possible.
my lord, can we take it up for final
I
disposal
think
next week?
you know it better than me.
No, my lord.
You know better than me. This court, no intent, cannot make the things upside down. We get chaos.
No, my lord.
This provision, I understand, it's a very interesting how they have read it to, you see, but then they cannot pass it.
My response submission is let this. I agree, my lord. I agree, my lord. Let this writ petition be disposed of by next week, my lord.
Well, just not next week, after 2 weeks.
No, my lord, because but in case, my lord, supposing if this is found to be not sustainable, then there has to be some alternative.
That will be very difficult, even if. Well, just will be, I think, that would be little, so far as the examination of the present examination is concerned, that will be little academic. Anyway, issue notice, we'll see next week.
Next week, my lord.
Can you?
Your lordship, no, at least 2 weeks time may be given.
Why?
Because the commission has taken as per the rules, action has been already taken.
So
and
that's
they
what I'm
have-
saying. Why 2 weeks? You think about on the rules, where on the rules,
Yes, your lord.
how the whether the rule has been properly interpreted, how you whether you have properly implemented the rule also. That's
Action has been taken as per the rule KB.
KB.
Your lordship. Yes, your lordship.
You see, this auxiliary verb
Yes, your.
or either of the two, prime facie, cannot be bought. Then you have to use and. Once you they apply the A, you cannot prime facie apply B.
She was disqualified as per the conduct rules of 2024 and
Yeah.
action has been taken as per the rules 2019. Your lordship.
Next week, 1 week. Cover it. Prime facie, I think you have wrongly applied. Heard Mr. Deepak and consent for the petitioner. Challenge made in this writ petition is to the order dated 24/07/2025. Issued by the where is this order?
Honorable, but this public service commission,
Where it is?
page 12, 61, my lord, annexure 12.
61. Passed by the
Arunachal Pradesh Public Service Commission.
chairman, the
Secretary.
secretary, APPSC, whereby the petitioner is debarred from the examination for a period of 1 year. Is to issue notice returnable by returnable in 1 week. 1 week.
Plot.
Since MS cannot do that concept, then is standing conscious for FPP6. The enters appearance, they have been responded. No problem with this. All right. Mr. Mitra, after a week.
Extra copy or not?
We observe 2 copies.
No, only one copy we use.
If or learned counsel will put in yourself 4 extra copies to that.
No. But the date may be fixed, but 18, 19,
19,
19.
19, 20, 20 page. 26, yeah.
Okay.
Item number 2,
Yes.
Super petitioner. Number 1, since it is a non-registered organization, so I am not placing this petition on behalf of petition number 1. But petition number 2 is concerned. Being the president in his own name. So on behalf of petition number 2, I'm placing this petition. So here, my lord, this petition, my lord, can be disposed, my lord, on the point of question of law. First, my lord, what happened? Sort of all details, facts, my lord, that the petitioner number 2, on coming to know that the private respondent, my lord, had fraudulently obtained the this registration certificate of a society of the Arunachal Pradesh Olympic registration. So that name, in identical name, this president, this petitioner number 2, they had been running the organization and they had even applied for the registration. So they made a complaint to the deputy commissioner because under the Society Registration Act, as well as the extension of this act in the state of Arunachal Pradesh, deputy commissioner is the authority who makes the report recommendation that which are applicants are entitled for the registration. The complaint was lodged raising this some false documents were used to procure the registration certificate. So after notice was issued, my lord, then after hearing the private respondent also, my lord, then deputy commissioner concluded, made a findings that the registration certificate was obtained fraudulently by using the force. Thereafter, my lord, the deputy commissioner, he recommends by letter to the registrar because under the Society Registration Act, it is the registrar who is the statutory authority either to issue the registration or cancel the registration. Then the deputy commissioner made the recommendation to the registrar saying that necessary action may be taken for the cancellation of registration. These are the. Now the imperial order is, my lord, that the registrar saying that I have taken the consent advice of the law department, and the law department has advised that since there is no specific provision under the Society Registration Act for the cancellation of the once issued registration certificate, therefore I don't have any power to cancel the registration. Basically, this thing. So only on the point, my lord, that whether the registrar has a power to cancel.
General Clauses Act.
Yes, my lord. Article 20, Section 21, 35 of Arunachal Pradesh, this general case interpretation, my lord. It says, my lord, power to issue, power to cancel also, my lord. It's very clear. So this is where, my lord, this understanding of the law of the register is erroneous and not according to law, my lord. So on this line itself, my lord, I have one citation also of our own High Court 3 J's bench. Similar matter of the state of Assam, my lord, where, my lord, again the same issue rose whether the registrar has the authority to cancel or not. And this, our honorable own High Court has said that this, by reading the article section 21 and the proviso of the Assam general clauses, said that power to cancel, it includes power to power to issue, it implies that power to cancel is also there. That judgment. So, my lord, at this stage today, without delving to all the issues, because now, my lord, recommendation has been made by the deputy commissioner in exercise of its power, my lord, to the registrar. Now, final call has to be taken by the registrar. Whether there is a case has been made out for cancellation. Now, that too, my lord, after following the procedure, that a hearing opportunity will be definitely given to the private respondent as well as to the petitioner also to advance their case. But not like that, yeah, I don't have statutory authority. On this basis, my lord, this petition can be disposed of. May I, my lord, so that judgment, my lord,
I'm not interested in judgment.
it's a very otherwise, my lord, yes, my lord. Open and shut case, my lord.
No, not open and shut case. I cannot say that. But then judgment is not.
Basically on article, this section 21, whether the registrar has a power.
Yes. Madam, ready? What do you say? Appears to be open and shut. Yes.
Even if it has to be read when also, can this matter be taken up tomorrow or day after tomorrow?
Why?
Lordship, I
Very
read-
simple matter.
Yes, Lordship. Of course, the registry also says that, Lordship, registrar society also says that there is no cancellation.
Is there any private respondent?
Yes, my lord.
Who is appearing for a private respondent? Anybody notice, sir?
Yes, but they have filed even their affidavit, my lord.
Yes. Who is appearing? Anybody appearing for the private respondents? What's the order? You can order.
My lord. Annex 525, page number 15.
By the law department.
Advised by the law department, my lord, and the registrar is his entire opinion is on
The law department has totally appears to be forgetting the law.
The respondent to registrar of society have taken this loan of the benefit also.
Revive the law department. Madam,
It's get paid by the
we do it for the private respondent. Yes, what do you say? Madam, what do you say? It's open.
This can be taken up, yes. It's can be, since private responsibility, but of their, otherwise our state is also taxing on. But the registrar of societies.
Very strange this instant.
Yes, okay.
The law department,
Yes.
I repeat, law department is forgetting the laws. Tomorrow, day after tomorrow.
My lord, then on Monday, Monday,
Monday.
Yes.
Friday is the Independence Day, my lord.
Next day, get it.
Yes.
I have some at somewhere, my lord. I don't know. Otherwise, my lord, for 20 also, my lord, Wednesday also no issue. Or 18 or 20. Yes.
What did you like to improve?
But it's us, not it.
Then we'll discuss. We may, like, I may make a Scott may make some observation against the law department. Don't mind.
My lord, this section 35 of the Arunachal Pradesh Interpretation and General Clauses Act 1980, that will be relevant. Section 35 of the Arunachal Pradesh. There is, it's in Arunachal Pradesh. What is it like? My lord, just
See, you say there is no provision for cancellation of the registration, therefore, by hands off.
Yes,
That what I say.
it's when we get to the law. Department.
No department has to be aware. Cannot be. Will advise, make an observation. Will it be appropriate?
It's better.
Or what? I mean, I'm open to, I'm hearing, we're hearing. What's the question of hearing? I mean, not ready. What's there? Method is very simple. The registrar has said, since there is no provision, he has acted on the advice of the law department, saying that since there is no provision for cancellation, so my hands up. I cannot do anything. They have forgotten the other law. I mean, law. You are good. We have enough time. Please. No, that is the simple matter. Matter is very simple. Registrar has said, no department has advised that there is no provision for cancellation of the registration. Therefore, my hands are tied. That's all. That's all. I'll justify that. And you cannot justify where MS at the she also hands up. put his hands off. So how do we justify? You are home. What's there? There is a law called Tenant Clauses Act. You are well aware. Very simple man. I agree with the land concept for the petitioner. It's open and substance. Very simple. You are not. What? That's it. That's it. For the past, it's open society. No matter registered. So it's the page. Registered society. Not for the complication. By the register of societies. But register of societies is the financial page. Issue of cancellation of parameters. Association of ordinance and conditions is disclosed on the is this that concept would be on the Mr. Udeca learn concept would be private respondents submits that he may be granted a week's time to prepare the matter. Although the matter appears to be appears to be simple. As by providing an opportunity to the then possible response. In consideration of the justice. That is what is to let this as agreed to by then possible party, let this matter be listed on
Either 18 or 20, Monday or
22 on 22
20 Friday, but I will almost
20
20.
2008 much. Mr. Dekha, you'll have to don't think that I am predetermined, but it's very appears to be very simple.
Yes, ma'am.
Item number 5.
Then compensation, madam. Petition is. Yeah, madam, we have filed our affidavit. Matter may be fixed for hearing.
None appears for the petitioner on call. MS. Huh? London State Council and Mr. Soicho appears for Soicho are present. Represent dismissed for non-presentation.
Item number 6.
What is the matter?
Eviction matter also. The petitioner. That was the backside of the quarter, including the half of the quarter was also demolished also. But you do get at page 7. There are some.
officer was initiated on the basis of the complaint filed by the housing authority as per their submission, as per their case. However, now housing authority, they say, no, we don't have any objection because the quarter now by their own NOC, they have issued the NOC saying that no, we have I have not encroached over the quarter and I have not demolished it. I have carried out the self demolition, but then I have not encroached the quarter.
You have demolished the quarter but they constructed a new building
No,
over the land.
it's not over the land because the quarter where it was constructed, it has gone. It falls under the highway. Now it's that land has been covered by the highway, national highway.
Yes,
The quarter where the building I have constructed is beyond the quarter. It was a swampy land because I was rendered homeless when I have carried out self demolition. So that I have developed that land. That too in presence of the former DC. So now they have come up with the NOC saying that I have not done anything with the quarter and I have not enforced the quarter because the quarter has gone with the NOC. Even the highway authority, they have issued the NOC.
where you have constructed your RCC.
It's beyond quarter. Earlier, the quarter was within the national highway. That quarter has been demolished and national highway authority, they have constructed national highway over the quarter. And the RCC where the building where I have constructed is beyond that. It was a swampy land. So
Have you been allotted?
I'm not allowed.
We don't know whether it's within the ROW or not, but then if it's not allotted, you have to vacate. I mean, you have to demonstrate.
However, Lordship, the adjacent plots, all the adjacent plots have been allotted. So,
But that didn't make it.
and the
That's why I'm asking, have you been allotted? Then,
but I have applied an
sorry,
allotment application. Lordship, at least let UT file the housing department file their affidavit because this entire proceeding has been initiated by the DC, estate officer and DC.
yes, they're the authority.
Now they
They're
have
the authority.
now the
Are they not the authority?
yes, they are authority, but then the place where I'm staying has been actually not the quarter which
We don't know. You have no allotment. It's a government land. You have constructed vacate.
let at least let the housing department come up with the because they have issued now the land is
The housing department is in your favor.
it's not that they are in my favor because they are the complaint has been initiated lodged by them only
Then,
and on the basis of that only this has been initiated.
no, then
However, in their own affidavit, they have come up saying that I have not encroached.
is it so?
End of the swap is no sort of that is
Are you in your affidavit? Are you saying that he has not enforced the land? Enforced?
yes.
Para 13.
When
Affidavit. Affidavit.
Yes.
Yes.
Affidavit filed by the
By whom?
by
There's only one affidavit. That's not number 3.
yes.
Yes. Para 13. Paragraph 13. Yes.
on the basis of executive order issued by the authorities I have demolished. So they have issued NOC. The UD department,
Yeah.
the housing department has issued.
You demolished and then again you have constructed.
No, the building
How
was-
how does it help you? Better 30.
because they themselves have issued the NOC.
Hmm.
And now the disease order, the while upholding the eviction order passed by the estate officer, the finding of the disease in page 95. Parate. On the above stated grounds and reasons, the order dated 1805 passed by the state by after 11. However, the husband of the applicants in
Who has passed that? Who has passed that order? No, who has passed that? Deputy Commissioner. Yes.
that the building was constructed by their hard and if eviction is carried out against the structure, it will be caused irreparable losses. Hence, rate for grant of property. A building constructed due of number of same the housing department. The compensation proposal placed by the husband of the applicants shall be placed before the competent authority for their consideration and comments in the eviction of the unauthorized structure shall stay. And in the meanwhile, the applicant is directed to vacate the unauthorized 30 days for the death of the order and the same shall be after death of that disease. By the estate officer, it is not open except on within order for the estate. So, as per this,
Yes, madam. Are you so generous?
Oh, Lord, about the company.
Big competition. Is that the thing? Are you ready for that?
have not constructed.
Why? Housing department.
Because otherwise, I have filed rejoinder against the affidavit passed by filed by the Deputy Commissioner. Because I have the NOC issued in my favor.
Okay, heard Mr. Arko, blood person for the police and MSG and then civil government, additional civil government. Huh? Still response. Huh? What did? What the? Stands nothing. Yeah, that also to the police. Well. Everybody. Right. Order pass a lesson. That you have to work out. It's not a isolated case. It's case. Find a solution. You allow them to construct and then well, deal with chaos. We've seen that for construction of the judges' bungalows here, I'm told the government is paying a huge compensation to the, I mean, people who have been allotted. And how they have been allotted is I mean, it's not a lookout of the lookout for us, but it's a ultimately company is a public money. Therefore, that. It's not a, I should let it this. Yes, sir. Tamam, sir. Look into all this thing. Where,
My lord,
how it's a government land, you have allotted wrongly or rightly. It's not, it's a lead.
correct, my
Now, people are claiming it has to be taken for a public purpose. They are claiming huge compensation. But this is something
something needs to be done in the allotment process
comprehensive.
itself, my lord.
Yes,
Process, because
no, lease. It's allotment is on lease.
it's not permanent, but not
Yes,
like
it's
a
on lease.
Yeah, correct.
That you are not, I mean, for we've seen it.
That's why, my lord,
This,
in the
uh,
allotment order itself,
Budget building also we've seen.
yes, a huge amount has been.
And this proposed, I mean, bungalows for the judges. I'm told there's something. It's a the government is very, I mean, it's truly a welfare government, but then money is public money.
Public money, correct, my lord.
Can you look into all this thing?
Some sort of mechanism is to be made out in the allotment process itself. Since you lordship correctly saying,
You have this, you have discussion and deliberation with the advocate general and the authorities concerned.
should be taken some bold step, my lord, correct.
They will be difficult. I'm just deferring it. I would have dismissed this case, but then I'm just deferring it just to only for that thing. Yes, it will have a ramification.
Absolutely, absolutely, my lord. I believe, my lord, if your lordship passes some observation, my lord, that might help them, my lord,
Yes.
to open their mind, my lord. in Future.
No, why we should give you a sermons?
Uh,
It's your job to have a deliberation with the concerned authorities. Something has to be done.
well, sometimes your lordship knows something, if something is not work, my lord, the things doesn't move in the right direction, my lord.
I forgot it.
Item number 7.
Yes. Right. Yes. What's the matter? They have a separate. No, they're not. They have filed the central government. But it is not even a rule. I don't know. They have not said how it's applicable to them. Of Page 17. Yes. But but then we'd like to know whether this is being good. Have you added this permanent? Have you filed the affidavit or affidavit?
That the fact they have not relied upon. Relied upon the whole. The government and the department are taking a bit of a contradictory stance.
What is your stand? The question is, when you are appearing for who? Huh? What's the question of limiting yourself? You are the states, sir.
But my first prayer is this, make some sort of regulation for get rid of the act.
Yes. Have you made any rules and regulation
Is it simple reason?
as mandated by the law? In the act?
Because in our affiliate, we have got state
Ah. Ah.
how he has been allotted. We have already issued them for
Ah.
this is. This is.
Whether it governs,
Because
It's covered or-
the part is concerned was department, yeah, department would be doing.
No, it's not the department, the state has to know. Sir. State has to know. State has to not know. State has to have the clear cut.
So, that's what I'm submitting. As per our affidavit, this is the office memorandum, where reservation policy has been adopted by this. This is our state. But another affidavit has come from the farmer law, which the copy served to me also. Now only I came to know that no such says. So therefore, we will sort it out also. Exactly, which one is the policy that is being adopted by this. I was not aware about this.
This office memorandum is no law, cannot law, be longer enforced. So the new act has come.
New exit.
Right, well, that can,
And you must be some semi pro.
no, this is just office, it's an advantage
Yeah, that's.
by
So
our.
we'll come with also press. I'll
Better. Okay. Don't bust the buck. This department, that department. Your mistake.
because of this,
It has to ultimately do something.
Yeah.
They may say, no, we will not give reservation for promotion for.
We said, Madam Topic was, looking for very heavy on.
look, I have got this. But because of dislocation between the laws and descending concern. So.
Sort it out. What is there? What is there?
Because this page 17 office memorandum, this is by
The
the
department is not in Japan.
No, that's true. But while filing the affidavit law, if copy is not served, like, that's the one
I think that
difficulties that we have to
you have to sort it out
correct.
in yourself. Okay. Heard Mr. Deepak learn concept for the petitioner. And also heard Mr. Estabi learn senior government advocate. For respondent number
1.5.
1, 2, and 5, and Mr. Elper, Stanley Council for Agriculture Department
For 3 and 4.
for respondent 3 and 4. Have you considered that no, although the respondents have filed their respective affidavits. The state from say appears to be bit contradictory as per the public, the office memorandum, which is mandated to be framed or issued by the state, by the spot, authorities. Let's let the bill set up so as to whatever response to come up with clear state, clear state, to come up with clear state, which may be put on record by web and figure. What is this categorical is for central government, department. So let us see that there be.
Item number 9.
As promised by Chief Justice, today it's a third day. So we cannot afford to, I mean, be lenient. Non appears for the petition on call. Mr. Unreasonable, then Additional Advocate General for the state and Mr. B. Or yes. But both private respondents. Yes. 9. Respondent number 9 are present. The petition stands dismissed for non-projection.
Item number 10.
Yes.
Plots he was selected. Thereafter, there is a verification of the documents provided by land verification company. The photocopy of the document lease deed he provided, long-term lease deed, it was found that a comparison with the original which is registered after the date of the application in 2024, somewhere around February 24. Thereafter, my lord, since it has to be registered as on the date of the last date of application, therefore we declared him as ineligible and he has been shifted from group 1 to group 3.
I want to explain the way of notarization of my paper. I have to explain yes. I file rejoin the registry from few days. You are not get it. Yes, it's what is called group 3. Group 3. Come on, let this matter be listed on 28. 2020.
For addition. Yes.
Item number 12.
Yes, sir. Yadav.
May Your Lordship.
Ah,
Lordship, as per the last order, the newly impleted respondent number 5 was supposed to file affidavit. But however, Your Lordship, respondent number 2, respondent number 3 and 4. 3 MK Committee is a registrar of nearest and respondent number 4 is director. So this director has been transferred. So respondent number 5 has been impleted. So Your Lordship, 3 and 4 has already filed affidavit in opposition, Your Lordship. So for respondent number 5, we are not filing,
it's not required.
not required, Your Lordship. Yes, Your Lordship. So
But
this,
Sir, RB, yeah, the plan council to the petition. MS, next para, MS, Enanju, then council to the response. Submits there. No, since, submits that, since an affidavit of opposition on behalf of respondent number 3 and 4.
yes, Your Lordship.
This court has already been filed. There would be, no, there would be no requirement for filing affidavit on behalf of respondent number 5. In view of that is better than for
Hearing.
admission. After
Okay.
Item number 13.
but it's a content. Content. Then have you complied or not?
Yes, we have complied. We,
If it's complied, what's there?
in our affidavit filed by the respondent number 3, we have already annexed.
Disposal, why, if there is no compliance, if not, it's very simple, but serious, but its implication is very serious. Implication will be very serious, but if it is complied, nothing. Yes, what is the order? Let us see.
Yes, Your Lordship. Yes.
Then. Your
Petition filed by respondent number 3, Your Lordship. Annexure 3, Your Lordship. Page number 17. Office order, in pursuance of
affidavit in opposition by
respondent number 3, registrar, Your Lordship. MK Kamdir. No, Your Lordship, respondent number 3, Your Lordship. Your Lordship may turn to page number 17, annex to respondent number 3. MK Kamdir.
yes,
Your Lordship, page number 17, annex to 3, Your Lordship.
17.
Yes, Your Lordship.
Yes.
17. in pursuance of the Honorable Court's order dated 9/12/15 passing WPC number so and so, and in the light of affidavit in opposition filed by Department of Higher and Technical Education, Ministry of Human Resource Development, Government of AP, against contempt case number so and so, the competent authority is approved for payment of officiating pay of registrar Neris to Sri P.K. Modak for the period of 27/9/2008 to 31/3/2011 with all consequential benefits.
Yeah.
Hence,
Going to.
next page, page number 18, is payment slip.
But it puts you- No, there's no concept at all. That is very, very clear. But there is maybe a minus plus according to your calculation, that is very clear, what is very clear, and you have been paid. But the concern, how much is a days or less, more than the awareness concern. That's what makes it's a contempt. Contempt proceeding. Or Mr. Sorry. What was it? Deleted, huh? Earlier. Or Mr. Anything? But we don't know. It's very clear. As to the courts of the officiating pay of registered in all possible countries and it's been paid. Maybe less or more, don't know. And Mr. Arbi Yadav, learned counsel for the petitioner. And Mr. MS and Najib, learned counsel for the alleged contempt. Notice that the audit dated 09 12 past the was
Yes, sir.
payment voucher. What is this? Payment.
Yes, Your
The payment receipt. Mr. The contempt petition states closed. Is that closed and disposed of?
Okay.
Item number 13.
Not happy. Not happy.
Because
Can't help it.
this order was passed in 2018 million. After that contempt was filed, that contempt was closed with observation that it did not paid fully. May approach this month from the report period. Again, he has given.
We will, although in this proceedings, last parent, in the contempt jurisdiction, no order is required to be passed. The petitioner is at liberty to approach, is liberty to make his grievance by an appropriate application. Now happy? Yes, madam. Miss, see that section.
Item number 17.
She's asking for solicium, madam.
Hmm?
And solicium, madam. And since the matter is pending in the apex court, madam,
Please put a petition.
Item number 18.
The respondents were supposed to take this. Respondents were supposed to file the affidavit.
There is same counsel, madam, for animal husbandry. Madam.
Paying some more time, madam. Veterinary. Veterinary. Animal husbandry.
If I
Lordship, there is an interim order.
Item number 19.
Report, my lord, for spot number 1 to 3, they're yet to file the spot affidavit. 1 to 3 are the government, my lord, still on for this. What's the matter? My lord, this matter pertains to the, my lord, this granting of this petroleum license to the private respondent in violation of the governing guidelines. Instruction, because, my lord, there is some guidelines where, my lord, some distance has to be made between two petrol depot, my lord. There has been violated. That is mandatory, my lord. The reason being, my lord, that this is in the larger. My lord, that's my lord. Recently, I've been engaged, my lord. I will look into this matter, my lord. I'll get other counsel.
violation of law.
Distance, my lord. There has to be some distance. Something, my lord,
Say, might be
something like that.
it's not.
No, it's just nearby. So why why this distance is to be maintained? So there is agreed means, my lord, first, like, my lord, that
If he not granted, you want it been granted.
no, I have already my depot. No, no,
It's all business liability.
that's why, my lord, whether this is permissible or not, because I have been just,
Guidelines, simple business liability.
my lord, yes, my lord,
Okay.
I have received this brief very, just few days back only, my lord. I had to do some homework also. And I think I may need to even file amendment, or if there is no case.
So, man, how to maintain? Somebody granted, it's a guideline.
My lord, I
Say your.
hereby, here.
Your business, like.
That's why, my lord, I will go through it, my lord. Just few days back only, because I was not the earlier cox. I just go through it.
That's remember.
No, my lord, I have to go exactly what is the case, my lord. That's why some time may be given, my lord.
Then often trust that you will
I will see, my lord.
according.
My lord, no, my lord, no require objection. Just some time, my lord.
Art is that the other plan for us, also that plan constitution. The matter is the job. Each. Then.
I did that. My lord, then, because if some case if came out, my lord, then I will argue, my lord. But I have not done. I have not done this exercise so far, whether simply or some case can be made. But that observation may not. Whether the observation may not be bad, my lord. This will curtail my scope of argument, even if some things, if I. Simple argument, my lord. First, today I am appearing for the first time. First time for this case. No, my lord.
Yes, after 1 week.
Item number 20.
Affidavit may not be record from the deputy commissioner because entire record has been called from the deputy commissioner, that is before the registrar. Records, the proceedings, disqualification process. What it was passed. I don't know, but there is a direction. What we can do.
Who is directing you? Sir,
But
take direct.
there was a direction to. No, my lord, regarding the production of the records from the deputy commissioner, there is a direction, my lord. But money, he can perish, not, I am not restricting that, my lord. Huh?
Who has directed me not to find that?
No one, my lord. No one. Why I've said, my lord, because entire. Yes, my lord. Yes, my lord. Correct, my. That's my stand, my lord. Because if your lordship insists, my lord, we should file the. Then, my lord, then we have to seek instruction from the deputy commissioner, my lord, Parawas comments.
On the basis of the report. No question. Let us stop allowing. Draftsman to draft the affidavit. Have some, trouble to write them.
But that will be better, my lord, because if convenience for all, that part I can understand, my lord. My lord, my lord.
Particularly specific. No mistake.
My lord. My lord. Why I've said, my lord, because our affidavit cannot change the records, my lord.
But
That's it. My lord. That's why I said, my lord, if my planner friend wants to perish the record, he can go ahead, my lord. I'm not saying filing reply. My lord, filing reply, not reply, my lord, if the lordship will satisfy with the records. Very well, my lord, we can, based on the record, we can file a short affidavit, my lord. Correct, my lord. I think that will suffice, my lord, 2 weeks time, my lord. And I'll be filing only based on the records available with us, my lord, because we cannot file beyond that, my lord. Because some fact. But basically, we can apply our amount, but provide the back because they know the fact better than us, my lord. So we have to rely on them, my lord. Okay, that's fine, my lord. Correct, my lord. Low, my lord, we can handle, but facts, my lord, they have to give us, my lord. That's why whenever we receive a paragraph control department, understood it is a stereotype definitely we call for the record so that you can tally whether your comments are correct with the tally or records or not we do that.
Art is that keep on learn constant repetition. For the state response.
Correct correct interim order was passed on the 310 if I correctly remember on that very date record was called for so your lordship has passed the order perhaps somebody must have insisted. Well,
Item number 22.
Vice comment, we filing it.
Matter is regarding the construction of circle official building over my land, and it has been admitted, with my repetition. I have erased all the document, that is the official document. Construction of what?
CO office.
CO office over my land. Yes. Without any acquisition and compensation. What is your what is the one instruction?
Yes, Your Lordship, because since petitioner they didn't show us any land possession certificate or land allotment certificate, Your Lordship, they don't have case.
My lord, it is not the onus is not on the petitioner, in fact, my lord. If the government has a land, my lord, yes. Yes, my lord. And it has also been admitted, my lord. It is their own document, my lord. The document, my lord, the order issued by the ADC. Are you not sure where you have constructed the Yes. Are you not sure?
Their CO office existed from 2008. There is, sorry, Your Lordship.
Anyway, not Mr. They come to learn concept with it. Please get the learn concept. Let's stick concept for the 3 weeks. My lord, that took too long, my lord, because my lord since my lord since my lord
No, Your Lordship, because
June.
this matter pertains to
Since
CO.
June, they are seeking time for filing affidavit, my lord. In fact, earlier, my lord, while this matter was being taken up in motion stage, this honorable court has directed them to produce the record. They yes, my lord. My lord, since there is no
You know, it pertains to DC
Yes.
Dapurejo. Okay.
now, if these 2 weeks is added, my lord, they will be taking almost this 3 months. My lord, I have the interim order, my lord. Already, my lord, but that is not that effective, my lord, because my lord has it was my lord court only, my lord, who has granted the interim order. It was to the effect that my lord, interim order. Last once the matter was issued last, my lord. Construction of the building will subject to the outcome of the writ petition. To be extended. Or till further order. Much of it. Much of it. No, this may be the last chance, my lord. That will, because we want, in fact, the community is ready to give land free of cost to the estate. This is just nearby the present existing CO quarter office. This way, even shown the place. Yes.
Item number 23.
I'm appearing on behalf of these of these out of session. I have instruction to make a prayer for the listing the case on 26, madam. In the meantime, he will file. Not madam. 26. Not yet, madam. That I am praying. Yes, madam. On behalf of these documents.
Mr.
Private. Right.
How many disputes is there? Last one.
Item number 1.
Yeah. What's here?
wants to develop his land, suppose wants to undertake earth cutting, then as per the government notification, my lord, that one has to procure the permission from the chief state official. And in terms of that, my lord, I submitted this representation, my lord, case number 67 on 11/9/2020. But my lord, my permission, my request was declined. Then my lord, next page number 68. Right, then page number 68, my lord. Then by this order, I'll just read, my lord. Obtain NOC from Department of Wild Warden and PW Division. In reference to the subject, the undersigned office have received your application that is seeking earth cutting permission of LPC plot at Lord Kutung Ganga village. You are required to obtain NOC from the Department of Wildlife Warden and the PW Division before issuing the permission for switch. Then, well, being agreed by this order, my lord, since it is contrary to the notification, my lord, the petition, the writ appellant, my lord, put to challenge this order by way of filing, my lord, writ petition number 358, my lord. And 358, my lord, will find at page number 70. The prayer of the writ petitioner was allowed, my lord, and this order was set aside and passed, my lord. And my lord, specifically by order dated 5/3/2021, my lord, from para 12, my lord, entire matter has been discussed, my lord. Just read, my lord, para 12. From the above abstract, it may be seen that private individuals, including the government departments, are required to submit application for obtaining NOC for earth cutting, and that along with such application, the required details such as photographs with geotech points for earth cutting and dumping area along with route of lifting quantity of earth, so and so and so, are required to be submitted. The petitioner in his application or admittedly did not impose such requirement. Importantly, the petitioner has also not challenged the notification. Therefore, in absence of challenge, it will not be feasible for the petitioner to question the requirement stipulated. At the same time, the respondent authority, having been conferred with the power to issue NOC, cannot in turn ask the applicant to first get a NOC from the Department of Wildlife Warden and PWD, as was done in the case of the petition. The order dated so and so passed by the deputy commissioner, it has been annexed as Annexation 3 of the counter affidavit of when the incumbent holding of chief state officer is authorized to act as the chairman of Ganga Lake Committee, and they further provides that he will coordinate with all the department lines, fisheries, social lines, so and so. Therefore, the respondent, in terms of the notification dated and order dated, has to consider and issue NOC to the applicant subject to the condition mentioned in the notification dated 7/1/2020 being fulfilled. The petitioner no doubt has the right to peaceful enjoyment of his land, but in terms of this intimation letter that he intends to construct an approach road near Ganga Lake, which is located at the capital complex, he will have to abide by the notification dated so and so. Thereafter, page 77, para 14, I'll just read para 14 or someone. There can be no disagreement with the law laid down by the apex court in the cases relied upon by the learned counsel for the petitioner that the right to property is a human right and that no person can be deprived of his property except in accordance with law. However, in the present case, the petitioner is not deprived of his property. He is required to obtain NOC in terms of the notification which has been prepared for regulating illegal earth cutting and around the soil. In absence of any challenge to the same, the petitioner cannot have any legitimate grounds, but at the same time, the respondent cannot relegate the matter to others, but will have to consider the grant of NOC in terms of the notification dated so and so. Now, last para 15. In view of above, the impugn communication dated so and so is hereby set aside. The petitioner, in order to undertake any earth cutting on his land adjacent to Ganga Lake, if so advised, shall apply for NOC from the respondent by enclosing all the requisite as stipulated in the notification 7/1/2020. The respondent, on receiving such application, shall consider and dispose of the same in terms of the said notification in accordance with law. The respondent will also be at liberty to make verification before issuing of NSC if necessary by consulting the Department of so and so. My lord, here at in this, my lord, writ petition, my lord, because my lord, this so far right to property, right to enjoyment property is a constitutional right and a human right, my lord. By way of notification, of course, that cannot be regulated. But of course, we have not put to challenge that notification. So now we are, because that regulation can be done only through the law as enacted by the legislature. Because it is very settled proposition of law by way of notification order, right to enjoyment of property. The state government executive cannot interfere with that one. But of course, we have not put to challenge to that notification. But here in this case, but even we want to comply with the notification, my lord, then in terms of the order passed by this honorable court, my lord, again we applied by complying with all the required documents, my lord, as stipulated in the notification. May I, my lord, get to the office notification, my lord, where it is said that what are the requirements that is to be there, my lord. Madam, may I take page 87? Because this notification is very important. Because direction passed by the learned single judge was to consider my application in terms of this notification. May I take my page number 87? Page number 87, my lord, at the below, my lord, clause 4A. I'll start from clause 4A, B and C, my lord. I'll start from A. My lord has got. The chief state officer so and so is vested with the power to issue NOC for earth cuttings in and around capital in exercise of his original power and function. The chief state officer coincides shall not issue NOC to any private investor for earth cutting without proper land allotment or LPC except government. That any person, including the government departments, while submitting application for obtaining NOC for earth cutting, shall submit the following document: photographs with geotech points so and so and so, number of DP so and so, quantity of work order with time, lifting, dumping, land allotment, LPC, and purpose of earth cutting under so and so and so. These are the requirements. One most point to be noted, madam, that the chief state officer is not the authority, is not equipped with the statutory authority under the Land Record Act to decide on the question of whether this LPC is right, this land allotment is right. This is not the domain, this is not the power which the chief state officer has been conferred. As my lord knows, chief state officer is appointed under the Arunachal Pradesh eviction of unauthorized. His power, additional power has been given by way of notification. But of course, my lord, this for to regulate the earth cutting, my lord. And now chief state officer has to confine within only the question that whether if any person who is having a valid land allotment, LPC, if he applies for a permission for earth cutting, my lord, now his duty, considering this office, my lord, memorandum, is that to see whether this 4A, B, C have been complied. And this particular point of law have been considered, taken note by this honorable court, by the honorable single judge, my lord, in the earlier round of litigation, my lord. Then, considering that part, because on earlier occasion, the chief state officer had directed me that you go and obtain NOC from the this wildlife board. My lord. Then the learned single judge said, no, there is no such requirement in the notification. Now, how can you ask the petitioner to go to the departments and obtain all NOC? This cannot be done. Then the learned single judge had directed the chief state officer that if the petitioner again filed the representation by compiling with all the requirement, you have to consider that. And my lord, thereafter, my lord, this representation was filed again on 15 March 2020 in terms of the order passed by the honorable single judge. Then all the requirements were duly complied. Then submitted. Then, my lord, I was asked that on and I was asked to appear to be remain on my spot on 6th April 2021 for spot verification. All day I waited in my place. Then the chief estate officer did not come. Then later on I came to know when I inquired when I visited the office, then only I came to know another interim order was passed this time, my lord. My lord, kindly turn to page number 84. Type copy, my lord, page number 84. Denial of NOC to undertake earth cutting at Lord Putu village. 84. Page 84, my lord. Here, my lord. Now, my lord, the ground. The notification is very clear that once you file the LPC, you have to give the permission. Now here,
You'll have to consider your application whether the NOC has to be given or not, my lord. And it is found that complaint, no complaint, on the basis of the complaint, it falls under the wildlife sanctuary. Before NOC cannot be given, that's all. Facts remains that it falls under wildlife sanctuary.
my lord.
Falls under wildlife sanctuary.
No. I am disputing that. My lord has seen long time back deputy commissioner in the year 2005 itself. That issue has been settled. Now 2005 onwards. Now,
No, factually, what do you, is it falls under the wildlife sanctuary or not?
factually, my lord, now other contention I have put, my lord, factually I have brought and report. This falls under, this is part of the Bath village. The Bath village comes under the excluded area, under this notification event. And this notification itself is in question, my lord, about formation of the wildlife sanctuary. First, my lord,
You are not challenging that.
not challenging, my lord, but that fact has to be considered when they are saying that this is a wildlife sanctuary. my lord.
Yes.
That has to be considered. I have raised that issue also, my lord, here. It's very interesting, my lord. Now, my lord, if we go by their statement, their map, my lord, then, my lord, then entire, my lord, only few place, my lord, only will remain. Otherwise, entire area, my lord, they are claiming. My lord. That's why, my lord, I have,
Cannot help you.
yes, my lord, I have brought on record that point, my lord. Now, my lord, first thing, I will come to that point. First point.
Wrongly or rightly, it's under the wildlife sanctuary.
No,
Accordingly, it's no, but as per the notification, it's false.
no, but I am disputing that one because I am saying is, my lord, that because my area, Lore village, it is on the record from the official website also, it falls under the Vad Panchayat Seshman area. And Vad is a excluded area. Vad village, it is an excluded area, my lord. So therefore, my lord, now the issue has become like, it has become a disputed question of fact, where the learned single, with due respect, has made a wrong observation without there being any material record. A concluded observation has been given that the land where I am proposing to take undertake earth cutting work, it falls within the wildlife sanctuary. That observation because there is no any material record to come to that observation. My lord. First, my lord, where the land. Now the situation is like that, my lord. Of course, my lord, chief state officer has to consider in terms of that one. Now, there is a complaint before the issue. Now this has become a disputed question of fact. Now the question has become now. Once earlier also this same issue was raised when the forest department says that this comes under our area. Then this honorable court, since disputed question of fact, directed the deputy commissioner to consider the issue. That was done in my favor. Now again same issue has been raised again after more than 20 years. Now the issue that this is the problem, madam. Now LPC is with me. Now, so for the law, so this whether it's small factor or according to small factor. May I, if you claim that this is it's an exclusive area, yes, madam. For that, may I make one suggestion? Now the issue, I am not here before, my lord. When I challenged, that the challenge was against the impugn order passed by the chief state officer. It's correct, my lord. It's correctly, it is not wrong. Yes, ma'am. Denying you the NOC for art. Yes, ma'am. Because yes, it falls under the wildlife sanctuary. There's a complaint from the department. Yes, it falls under that. Cannot be allowed. Now the question come again, madam. That this disputed question has been resolved in terms of the order passed by this honorable court itself. Then this is another issue. Now, my lord, the court has not decided the issue, my lord, whether it's under falls under or not. My lord, in that order it says that the forest has no right over my land, and that has been recognized. Honor. Now, even my lord, even today, now my submission is that, my lord, if whether this falls under not falls, my lord, deputy commissioner is the appropriate authority to consider about whether my LPC has been rightly issued or wrongly issued, my lord. Because chief state officer is not the authority. Now, deputy commissioner, in terms of the exercise of his statutory power under the Land Record and Settlement Act, my lord, has issued the LPC. That statutory power has been conferred on the deputy commissioner. Now, the presumption will always be there that this LPC, my lord, any official act, the presumption goes with that one. Now, presumption is that LPC is proper, man, because LPC just cannot be mechanically issued, man. Now, when this presumption is there, madam, unless it's not been admitted, not my lord. Yes, admit next day, otherwise we are not inside. Admit then, madam. I have so many arguments.
One question. You said that there is a house already being constructed in your area.
Government
Inside the LPC.
Inside the LPC, the
Okay.
10,000 areas have been gifted to the government.
No. What about that? Have you lodged any complaint against that?
No. That work was awarded to me in lieu of compensation for my land LPC.
So there is a black and white document on that.
Yes, I have brought on record. Building is there, my lord. Just that area when just near the Ganga Lake, just near this VIP car parking lodge.
No, whether has it been reduced into writing this agreement, this arrangement that you will be given a contract in lieu of this land?
my lord, here, my lord, government, when they were denying the payment, my lord, I wrote the legal notice. Then their reply I have enclosed here where they said that no, we will not give you compensation for the land since we have awarded you the contract work for your land. I have brought on record, my lord. And building is still standing out of my 50,000, 10,000 area, my lord, already I have donated to the government. But of course, I executed the contract work.
How you can donate if it's the falls under the wildlife sanctuary?
No, that is a disputed question of fact. Now,
You first clear and come back. Well, admit this. It's a notified wildlife sanctuary. But if it includes the Nalagani Tana.
nothing remains.
We in that case we may refuse.
My lord,
Because
it includes everything.
Me and my brother has the allotment order.
Yes. But
Brother-
Lekki village is not exempted. It
No.
also under the
No, Lekki village or not. I have my this thing in the Barapani.
Barapani. Yes, my lord. There is a issue.
Tomorrow, if we say that this notification is not sustainable,
Yes.
then there should be a conflict of.
My lord, it will be wise, my lord. It will be wise to recuse. My lord.
Better to.
Yes, my lord.
Let us see. What is the notification? Area, walls, it covers turnover and Naharlagan.
Yes. And so, page 16, my lord, if I may, submitted by the respondent, then my lord will find only
Turnover. Munga village.
payments.
Not sorry. You have the allotment or government allotment. In Itanagar.
This is my entire our almost 80% of area inhabited by the people. They are saying that this is and my lord, this notification itself is issue.
Yes.
How?
I have refused.
Yes.
What matter?
My lord, question, my lord.
But this thing in the division.
How this much of area?
Monday, what method? Some, I refuse. Putting it cheap. It's almost the same thing. Because tomorrow we say, if it's not.
Yes, my lord. My lord, if gives in my favor, then then because I have raised the issue of my lord this notification because this is not a gadget.
And then you better you also. You have the allotment order. Whose name? Whose name? Your husband. Send it. You're better now.
The manner in which this has been created, I think
No,
legally not tenable.
it other effect. But then the basis would be the notification. Basis would be the notification, right? Notification is it includes the notification includes the Itanagar, Naharnagar.
Bandardua, Holongi, everything, man. Then our entire, my lord,
Yeah, practically it may not be possible, but the wrongly or rightly there is a notification.
notification, my lord, not as per the law. This issue I have raised, my lord. Now they have to satisfy that this creation of wildlife sanctuary, first, my lord, from reserve forest, wildlife sanctuary cannot be created. Number one, illegally. Indian Forest Act, my lord, clearly says, my lord, that reserve forest cannot be converted to wildlife sanctuary.
Sitting as an appellate court, it is interport, you cannot decide that. What is your basic claim?
My case is, my lord, that so far,
What you are saying is that the state officer has no right to reject your NOC just on the basis of the complaint.
complaint and, my lord, when there is a, my lord, existing LPC is there, the state officer has to, state officer has to confine with that LPC. Presumption is there. That is the valid thing. Until it is revoked, cancelled, and as on today, it has not been cancelled.
No, Itanagar is excluded from the thing.
Some portion, not entire. Some portion, it's very minimum area, my lord.
See, otherwise, why not inclined? Why not inclined, but then not disturbed?
And, my lord, I am basically agree by the observation made by the honorable single judge without there being any materials on record that a conclusive finding has been given that this my LPC area falls under the wildlife sanctuary.
Now they have already filed the affidavit. We can consider.
My lord, as on, my lord, as on today, LPC is existing. If it is revoked, then my case would be definitely different, my lord. I would be challenging at that point of the LPC. When the LPC is existing, my lord, can we presume that this LPC is wrong? The law says that presumption will be there. This is a genuine document. Properly issued by the official in exercise. Presumption, law presume in that way. Evidence Act says like that. Every official act is presumed to be legitimately done. If it is wrong, this is a subject matter to be decided by the deputy commissioner. Now, on the pretext that there is a complaint, how the chief state officer can, for whole the time, my lord, if it is so, my lord, if it is so, the deputy commissioner has to initiate the process for cancellation. Then I will put to challenge that process if it is not done or in what basis. No, my lord. Law says, my lord, until and unless any official document, until and unless it is not revoked or cancelled, the presumption is that this is a valid document. Now, otherwise, what will be the sanctity of any official document if every presumption is not like that, that this document was wrongly issued. Presumption is that it was rightly issued. Then the person who alleges that this has not been rightly issued, onus lies on the person.
Are you for the deputy commissioner? The which for deputy commissioner is the party.
It's not the point.
You are appearing. You said, issue notice to him, cancel it.
But that's why LPC, if they cancel, then that will be
If you, no, if you have found that it has not been properly issued and not following the due process, why are we stopping you? Cancel it. By simply issuing a notice.
that will be another subject matter, which I will be challenging. But my case here is not on that point. My case is that when there is a
No,
bill-
when you know that the LPC, if we are it's brought on record that if the LPC is not issued by following the process and the procedure.
my lord, who will decide? My lord, question comes: who will decide that this has not been processed according to law? It is the deputy commissioner has to decide. My lord, now who will decide? Is the chief state officer or the forest department will decide? The statutory power to issue the LPC
LPC is issued under which law?
under the Arunachal Pradesh, this Land Record and Settlement Act.
When it was issued?
It was in 2005. Was issued in 2005.
Show us the
2000.
show us the provision when the land LPC is issued. 2012 rules. Yes.
No. My case is like this, my lord, that once direction was passed by this honorable court, deputy commissioner adjudicated the matter, found that no claim is wrong. Thereafter, I applied. It was issued by the deputy. As on today, even deputy commissioner, by either way, my lord, because now there is a issue, whether under the Land Record Settlement Act, under which provision, because government office memorandum, this clarification is given that the deputy commissioner is conferred under the 2000 Act to issue the LPC. But before that also, there was a of government notification, my lord, conferring the power to the deputy commissioner to issue the LPC to the land which are the private. In my case, my lord,
That point of time when the LPC was issued, it was under the guideline,
guideline.
not under the rules. Because rules had been framed in 2012 only.
Yes, my lord. Then, my lord,
And even that guideline was not followed while issuing the LPC.
be that is me, but ultimately, my lord, that was issued. My lord. Now the question is that I am not saying, my lord, that once issued, it cannot be cancelled. This is not my case, my lord. Error may crept up there, it can be cancelled. My the question is that, my lord. Now, without initiating the cancellation, without cancelling any,
Direct them to initiate.
no, initiate means that's why, my lord, my lord, it is something like that. Deputy, that this observation has created a wrong. This has prejudiced me, my lord. Now, how will, my lord, my entire case is that this area falls under Vad village. I have think, and Vad Panchayat village also sent. And Vad village is an excluded area from this notification. And apart from, my lord, and even the forest has to, my lord. My lord, if tomorrow matter is taken before the deputy commissioner, for example, forest has to satisfy that how they created this wildlife sanctuary. Just by saying sowing map is not enough. Whether this was created,
You are not challenging all this.
no, my lord.
Not the issue there.
Now, my lord, onus is on them that this has been created properly. I don't require to challenge, my lord. Now they, if they, because
It's not a
I,
question of requirement. Your issue here is whether the state officer has validly rejected your issuance of notes to a form.
and whether
We find that
My lord.
yes, rightly rejected your endorsement.
but still, my lord, when there is a valid LPC, because the in terms of the direction passed by the Honorable Coordinate Bench, single bench, my lord, to the Chief State Officer.
Wow,
That is the matter.
how you have obtained it?
My lord, that is the matter to be, once this has been decided, once this was decided, if my lord is saying second round of litigation, second round of verification is to be done, of course, that's up to the my lord's discretion, my lord. Once that process was undergone, after 20 years, again, if my lord says me, you have to again go for that verification that whether your lord, yes, that is a different issue. I am not on the point. Today, I am on the point, my lord, that prejudging the thing without hearing any basis, my lord, by the learned honorable due respect, learned single judge.
We are not a regular.
My lord,
LPC, what?
my lord, this is, there was a complaint. There is a complaint, but
Yes,
it is still valid.
Prime Minister is false and then well,
My lord, that part has to be, we, once this was decided, now again, now then, my lord, this earlier findings, it has become known.
very definite.
My lord, but my lord, today, my lord is, you know, whether they are being, when I am disputing the rate, there is no materials to come to record. So only because a complaint was filed, is it sufficient for the honorable single judge to conclude that this area falls under the
Why not?
wildlife sector?
Why not?
Well, only,
Why not?
only on the basis of
Now
complaint.
they find that.
So this is the dispute.
Why then it falls under well.
Then it has become a dispute question of fact. And I have raised that the manner in which way this wildlife sanctuary cannot.
No longer it's a dispute. There's a clear notification has been added. That will in 1978.
But my lord, I have one judgment, our own body high court, where the notification, not gazetted notification, then decline to recognize as a violation.
Are you challenging?
No, in that case also nobody.
Challenge
No,
that.
it's on them to satisfy. It is on them.
Once satisfied, then it's falls under the order.
Now the question remains one. Now, my lord, my LPC presumption is there. My LPC is still valid without cancellation. Now it will happen something like, what's about this LPC? The law says, notification says, whoever possesses the LPC, right to exercise, right to enjoy that land is that requirement. Now I have a valid LPC. Now, spite of having a valid LPC, it's not it, my lord, that I have been deprived of. I am not saying that if the forest department says this is false under, this matter has to be before the competent authority, my lord.
That's right. That's why the legislature rightly observed that your LPC is under law.
My lord, under the
Rightly
law.
observed. Anyway, by proposing to another.
Well.
They observe that judicial the process for cancellation. To do it.
But this observation, my lord. Then, my lord, this observation, my lord, it's not tentative observation by the honorable sir. There's a conclusive observation that has been made. This falls under the, only on the basis of, I am agreed by that observation. How that observation would be made.
Just saying that without any fact. Here we have the fact clear. Notification is there, that is there.
Then, my lord, my another arguments, my lord, I have to close the matrix, my lord. My lord, my case is like that. This
Well understood.
Bath village, even we, two leg of argument. First, this,
Sir, we have understood
my lord,
for the last 1 hour.
my lord, my lord, my lord. Some, better may fix for hearing then, my lord.
Another. You also think about it. And you also think about it. The consequences tomorrow. The perception and there should not be any. I understand. It's a no, it's a particular. It's a particular area, but then see. But the brother has pointed out there are certain questions of excluded. It's been excluded. Tomorrow if it falls in the unlikelihood and where to get development. I mean, near favor or I think it's favor of your proper. You think about it.
So issues are there, my lord. Legal issues are even there, my lord.
Or Mr. Arsona then constantly. And also had appellate, and also had